Bowen, and I am a Madison resident. We did get some questions from parents in the community about Board Policy 5756, transgender students, a policy currently in effect that applies to students in kindergarten through the 12th grade. These questions deal with the section of the policy called student-centered approach. We are asking for the superintendent and the board to provide full answers to these items at Board of Education meetings for the public record. So we're going to name several areas of the policy in that section, and then there'll be questions relating to them. First, with regard to Policy 5756, is it a correct understanding that a parent will not be informed of a student's gender change if the student does not want their parent to be informed? If that's the case, the question is, without informing the parent that their child has chosen to self-identify as a different gender, and without having access to the child's full medical and mental health history, which only the parent would know, how can the district be certain that affirming their newly asserted identity is in the student's best interest? Without knowing their full medical and mental health history, how can the district ensure that affirming the new gender would not conflict with the student's doctor or therapist's recommendation? Second area of the student-centered approach. Is it true that a school district at its own discretion, not a court of law, now has the right to decide whether or not a parent is fit to know pertinent life-changing information about their own child, such as a child's gender, name, and profile, pronoun change? Third, the policy also states that, quote, in the event a parent objects to the minor student's name change request, the superintendent or designee should consult the board attorney regarding the minor student's civil rights and protections. We would like a clarification. Please clarify whether this consultation describes an adversarial legal action to the parents due to a parent's questions or perhaps disagreement with the child's identity, asserted identity. The policy also states, quote, school districts should be mindful of disputes between minor students and parents concerning the student's gender identity or expression, end quote. It goes on to list New Jersey child neglect websites, like DCPP, which is the new name for DIFUS, and the Child Protective Services as support resources for staff. Our question is this section directing school staff to report students to Child Protective Services on the single basis that the parents may disagree or question, or may not be on board with the student's gender, name, or pronoun change? And finally, again, student centers.
Just make sure you wrap up right now. That was your time, but if you have one more thing.
I think we can wrap up in 30 seconds. The policy also states that the principal or designee should discuss with the student and any other individuals at the student's request risks associated with the student's transgender status being inadvertently disclosed. The principal or designee will inform the student that the transgender status may be revealed due to other students' discussions at home. Does this mean that other students, friends, or classmates of the transgender students may be called in by the principal and asked to hide or keep information from their own parents regarding the transgender identifying student so that they do not accidentally out the transgender student to their family? We thank the Board of Education and the superintendent in advance for providing full and detailed responses to each of these questions at Board of Education meetings, so these clarifications can be available to parents as part of the public record. Thank you.